Welcome to Chromatic Counsel Podcast, the podcast where leadership, law, and color collide. I'm your host, Carrie Heaps, and I have a great show lined up for you today. Just a quick announcement, if you are licensed in Texas and Florida, I hope you will check out the Digital Tells, How to Read Body Language on Zoom. You can check out the link in the show notes below to see if we have any upcoming dates that you would like to attend, and it's also available on recording. And if you'd like to see the other offerings that we have, you can check out the CLE catalog just below that. And today I am really excited about my guest. Today I am joined by Dr. Melissa Pigott, a nationally recognized social psychologist and one of the country's leading experts in jury research, litigation strategy, and alternative dispute resolution. She's the co-founder and director of research at Magnus Research Consultants, where she designs customized decision research programs for complex litigation, including mock trials and jury attitude studies across the United States. Dr. Pigott, welcome to the show.
Thank you. And thank you very much for inviting me. I'm excited to be here, Carrie.
Absolutely. And I'm excited that we were able to work it out where you could come on the show. For those of you who probably have taken some of my CLEs before, I have referenced the Summerly podcast where Dr. Pigott was a guest on the show talking about jury research. I've talked about that for additional CLEs. So some of you may recognize her name from that, or perhaps just in the industry. But I would love for you to share with our listening audience just a little bit more about you, because you've been involved in selecting, I think it's more than 200 juries. And I would just love for you to share a little bit about your background maybe, and what are some, I'd love to know about some common mistakes that attorneys make during voir dire that could cost them the case before the trial even begins. And I'm sure that probably factors into your background as well.
Okay, thanks. Well, we're off to a good start then. A little bit about background is I have a PhD in social psychology, and that's the psychology of how people make decisions in a group situation, not as individuals, but as groups. So, of course, a jury is a group, arbitration panel is a group. So we look at ways that people make decisions differently than when they are on their own, they can do whatever they want. I've conducted jury research for a long, long time, all the way from Alaska to the Virgin Islands and pretty much everywhere in between. I'm a native Floridian, so my specialty is working here in Florida, and my office is based in Pompano Beach.
Mhm.
Done thousands of mock trials, and yes, I've selected over 200 juries. And this is a good question to start with, Carrie, because I have several publications, and one of them is titled 25 Common Mistakes Attorneys Make in Voir dire. But our time limitation today is such that we don't have time to talk about 25, so I've picked a few.
Okay.
Yeah, we could be here all day on all these good questions we're going to talk about. So the first one is not asking the jurors, all the jurors, questions. If you have a venire panel that's got 30 people, well, you need to talk to all 30 of them, because guess what? That person in the back row could end up on your jury. And then what are you going to do if you haven't ever asked him or her any questions? First of all, you don't know anything about them. And second, you've hurt their feelings because you've excluded them. So I have to nudge attorneys all the time. Hey, we don't know anything about number 17. Come on, ask questions. So that's the first one that comes to mind. Seems obvious, but I guess it's not.
Mhm.
Next would be failing to ask follow-up questions. I've heard some attorneys say, okay, well, we're just going to do this on the show of hands. I don't want to hear from anybody. Oh, no, 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 no. We need to say, how many of you have ever had this experience with a medical malpractice or something? Raise your hands. But for the people who have their hands up, tell me about it. What happened? What'd you do? Not just raise your hand and move on. So that's another one, failing to ask follow-up questions. Next would be, oh boy, and this is a serious one, stopping short in setting up challenges for cause. Attorneys know you get challenges for cause, and those are people who say, I absolutely cannot be fair for whatever reason. But the attorney has to go through several steps to convince the judge that there is reasonable doubt about that juror's ability to be fair. And I have a lot of attorneys who get almost there and then they stop short. And when that happens, you have to use a strike. And
Mm.
maybe you only have 3 strikes. Sometimes you get lucky, maybe you got 6 strikes or even 9 strikes, but you could have lots and lots of challenges for cause. So you've got to go through the steps to set up the challenges for cause. Otherwise, it's a dangerous situation. Next, I'm a social psychologist. I know all about stereotypes and prejudice and biases. Attorneys, a lot of times, use stereotypes when selecting a jury. They tell me, oh, well, I never put a teacher on my jury. Oh, no, no, no. I never put a postal worker. Well, if an attorney is using stereotypes, and they're going to strike those people based on nothing but a stereotype, guess what? They may be wrong. And there may be somebody else on that jury who's a whole lot worse than the person who's been a teacher or a postal worker. So you really need to get to know these jurors. You can't just say, yeah, you know what? I'm in a hurry. I'm just going to go as fast as I can. And that's not how you do it.
Yeah.
Yes. Got one more.
Yes, I would love to hear it. Yes.
This one's a serious one too. And sometimes I shake my head about some of this stuff. The last very serious one is for an attorney not to be familiar on the law with for jury selection. There's case law on jury selection. Some of the judges need a reminder. It depends on if attorneys are in state court or federal court. For example, federal court, there's no backstriking. I had a terrible argument with a client in the courthouse who said, no, I'm going to save this for a backstrike. We were in federal court, and I kept saying, okay, big boss guy, just wait. And
No.
so he said, okay, judge, I'm going to backstrike this one. And the judge said, there's no such thing as backstriking in federal court. So that kind of thing, you know the law. I mean, that's their job, not mine.
Yeah, and those are all interesting. And I just wanted to ask because like the follow-up questions, and I think you're right. I have had some trial attorneys that have said to me, just in conversation, that they were talking about like, when they do voir dire, how they'll see another attorney who they really struggle with what kind of questions should they be asking? Like like just in general, but then also too with follow-up questions. Um, and I, as a former, like I've done a lot of pageant judging, which everybody's probably like, pageant judging, that has nothing to do with anything. But pageant judging, I mean, we're typically on a panel. We have, different questions. And over the years, because I've done this so much, I have a list of questions. And what I did just for, I was like, I want to see how this works. So I took all of my pageant questions and I'm like, how would this translate into voir dire questions? Like, could these work? And I put it into AI just to see what would happen. And it was interesting, all the questions that came back, because I was like, I shared it with them and I said, do you think this would help? Just to give people ideas. And he goes, yes. He said, a lot of times attorneys, he said, you'd be surprised. Like they're just like you said, like they're asking, not that it's not an important question, but they're kind of like, okay, I got the answer, and it's dead in the water at that point. Like they're not doing anything else. So I mean, how much do you feel that this is because maybe trial attorneys are not doing that many trials? They don't have that much experience with it. Just like with the law, like you said, state and federal, with picking a jury, there's different rules. And do you feel it's part of maybe the experience for them, that maybe they don't have that much experience, or that they're just overwhelmed? Do you think it could be an underlying reason there, that they're not putting more time and effort into it, or perhaps they're not hiring the experts that they need, or bringing experts on board?
There's a couple things. I think, yes, they're not as experienced as they used to be. I have clients who haven't been to the courthouse in 10 years, but they call
Wow.
themselves a trial lawyer. So
Yeah.
that's one thing. They're rusty. And another thing is they don't practice the voir dire questions. They're focused on getting ready for everything else, opening statements. And if I'm working with the attorney, I write the voir dire questions for them. All they have to do is read off a piece of paper exactly what I write. Don't change the wording,
Hmm.
which they like to do sometimes, and that messes us up.
Yeah.
But a lot of it comes from they just want to pick a jury and move on because they just aren't comfortable with that aspect of it and they just don't practice. And the same with the follow-up questions. You have to practice the question and then what if somebody has a follow-up? How am I going to deal with that? And it's just kind of dead silence a lot of times. Uh-oh, and
Yeah.
then we can see their face. Like, I didn't think about that, did I?
Yeah. Now, I know you touched on biases briefly, but from your research, mock trial work, what are some unexpected biases that jurors bring into the courtroom that attorneys may not even realize are influencing decisions?
That's a great follow-up. Most everybody has some sort of worldview or perception of the way things should be based on their life experience and their personalities and things like that. And they do
Hmm.
have biases. One of them that really affects how they view the case is if they are pseudo experts on the subject matter. And we see that all the time with the mock juries. Somebody says, oh, well, I've done this activity many times. I know all about it. And if you have a person like that on the jury, they're going to run the whole show and they may not have as much expertise in exactly what the trial is about as they think they do. So that's a real danger.
Hmm.
And related to that, somebody who has considerable similarity to one of the parties, the plaintiff or the defendant. And a lot of times plaintiff lawyers will tell me, oh, yeah, I want that person because they've been through exactly the same thing. Well, no, I would say that's probably our first strike if we have to use a strike instead of challenge for cause, because psychologists know about defensive attribution.
Hmm.
This could never happen to me. Well, I wouldn't have done it that way. I wouldn't have gotten hurt. I wouldn't have chosen that doctor. I wouldn't have selected that roofer, contractor, whatever it is. And it goes exactly the opposite from how you would think it would. So that's a real danger. Um, Next, specifically for plaintiffs' lawyers, is a bias is somebody who has been through something similar to the plaintiff, or they know somebody close to them who has been through something similar, and they didn't get any money, and they're doing just fine. Thank you very much. Well, guess what? If that happens, then the plaintiff is going to get probably about the same amount of money, which is zero, that person that they know got. So people
Hmm.
don't think about that, but that we hear that all the time on the mock juries.
Wow.
And then let's see. Oh, another one is if somebody has let's say, an axe to grind or a personal vendetta that they want to get over. We had a case many years ago involving a bike rider in a bike club who was seriously injured. A car ran through the bikers in the bike club and he survived, but he was very injured. Well, turns out a lot of our mock jurors hated people who wear stretchy bike shorts. They hate the bike clubs because they hog the road or whatever it is about bike riders. And we said, oh my gosh, I mean, we never thought about that. And same for the defense side. If somebody says, oh, you know what, I just hate big corporations. I'm never going to shop at fill in the blank big store. And this has nothing to do with that, but
Hmm.
it's still a big corporation that's being sued or an insurance company that everybody knows is behind the scenes, then forget about it. That's all there is to it.
Wow. Obviously, so in high stakes cases, because you deal with a lot of them, what tends to matter more than jurors out of these three things? Is it the facts of the case, or the credibility of the attorney, or the story being told, or is it all three?
It's all three, but based on my observation of thousands of mock jurors, you'd be surprised. They really pay attention to the facts of the case. They take notes, they're involved, and I believe the real jurors, the trial jurors, are just as involved as our mock jurors. So they pay attention to the facts, but the attorney's credibility and an interesting story are definitely requirements too.
Mhm. And when you work with legal teams before a trial, what does effective trial preparation look like from a jury research perspective?
Okay, well, we do attitude surveys, and they used to be picking up the telephone and calling people, but that's not how we do them anymore. We do
Mhm.
text to web. We've joined the modern world. We do focus groups and mock trials, and in all of those things, we usually test the verdict forms, we test the jury instructions, test the demonstrative evidence. We have a lot of issues with the graphic aids that attorneys use. They put too many words and nobody can read it and it's boring. So we have to rework those for them. We evaluate the attorneys. A lot of times we are hired by the insurance company or the end client who says, I've got some concerns about my attorney. So I want to do this and see if I want them as lead counsel or I want somebody else. So that's part of what we do. The main thing is the attorney needs to involve us early so that we can have time to change the case around, and they also need to be involved with us ahead of time. If we ask for, hey, let's get together and have a short meeting on the phone to talk about what we're going to do on the jury research day, then we really need to have that meeting. We can't just show up and kind of say, okay, everybody do the best we can.
Mhm.
And after the fact, I write a lot of recommendations and we need to go over them, make sure everybody understands them, make sure everybody's on the same page, discuss those voir dire questions, and really get ready. You can get out of jury research basically the effort that you put into it. You just can't say, oh, well, I'm going to do this and then never pay attention to it again.
And I think you're what you said earlier too, just about the verbiage and the wording, because I think too sometimes attorneys forget that the people in the jury, they didn't go to law school with them, you know. They're like, you have to have things that are broken down and just in plain English. You know, I think too and I think for some that's a challenge for them to do, you know, and I think that's where bringing in a jury consultant and you know is going to be super helpful for you know those attorneys. So how can attorneys use mock juries or focus groups strategically to refine their arguments and just better understand how jurors might interpret evidence? And I want to ask this question because I think too sometimes maybe people are looking at, you know, hey, we're going to hire a jury consultant for this trial, but not like it's just for that trial, like they're not utilizing what they learned in all of the other trials that they're doing. It's kind of like they're not bringing it over per se, like it seems like it's just kind of a one and done thing. So I'm just you know curious to see you know what your thoughts are on that, about how they can use their experience with the mock juries and focus groups strategically.
Okay, good question too. Well, all of our research is case specific, but there are definitely things that people can learn and use from case to case. The main thing is do things early. We have a lot of clients who say, well, I'm so invested in this presentation of the case, I can't change it,
Mhm.
or it's too late. I can't hire any more expert witnesses. And it's like, oh no, but we need to, because what we do a lot of times is we turn the case upside down and inside out.
Yeah.
And we have to have an attorney who is open-minded and willing to listen to advice and to do something about it. One of our most famous criticisms that we've ever had in all of our years of business is a client who told my business partner, well, I learned a lot, but you should have forced me to do this earlier. It's like, well, we don't force anybody to do anything, but you've just got to think, okay, how am I going to maximize what I've learned and how can I learn across all the cases, especially if I don't go to trial very often. That's the main thing these days is people really get out of practice, I think.
Mhm.
And it's important to remember that when I'm involved, all of my research participants fill out extensive surveys, and my recommendations are based on scientific data. They're not based on, oh, yeah, well, that one looks good to me, or yeah, that's kind of my gut instinct. That I don't do that at all. So I may have a difference of opinion with an attorney, but we can work that out.
Mhm.
And everybody has to recognize the client is the ultimate decision maker. I'm just going to make a lot of suggestions and they can accept them or reject them.
And you touched on expert witnesses, and because I do interview expert witnesses here on the show, probably about one a week, I would say. And do you typically, when you're working with a client, I guess it would just depend on the case, but are you an advocate for bringing on those expert witnesses, or is it just like unless it's absolutely really needed?
Most of the cases that I work on have experts on both sides because we work on really high stakes, complex litigation. No one hires us for something that is easy or small dollars, low value. So
Hmm.
they usually have experts. Sometimes I do witness preparation for the experts, especially for medical doctors or engineers, people like that who know their subject matter but really don't know how to make a nice presentation in front of people.
Hmm.
So the experts matter. And again, from the mock juror's perspective, sometimes they say, oh, well, this case is kind of common sense. We don't really need the experts, but typically they rely on the expert testimony quite a bit.
Hmm. And, from a jury psychology perspective, how much does attorney presence and communication style influence juror trust?
Mm, a lot. We talked about the facts of the case are important, but if the jurors don't like the attorney and or the client, then the case is pretty much over. Um, we ask all of our mock jurors to do attorney ratings, as I mentioned before, and some of them are highly critical. We've had a couple glaring examples that I thought the viewers would like to hear about. I had
Mhm.
one a long time ago, and I told you I have my jurors fill out surveys. Well, typically after the plaintiff's presentation, they award a sizable amount of money because, again, it's a big, serious case. After they hear from the defense, the monetary award goes down a little bit. When they hear rebuttal, maybe it comes up a little bit, and then the deliberations results can influence this last survey. So it's somewhere in between. But we had this one after the defense presentation, the damages were twice that of after the plaintiff's presentation. And the mock jurors said they absolutely hated the defense attorney and everything about his appearance and his presentation. And they would have awarded $100 million trillion if they could have. And that's, of course, all on
Wow.
video for everyone to hear. So it matters. We have another one, and this one you'll like because you like to do the wardrobe and color stuff. The mock jurors said, well, the only thing I can say nice about that attorney is that he had a really pretty purple tie. That's it.
Mhm.
So you know that he lost the case in terms of the mock trials, and it went to the other side just because there was nothing else about him that they liked.
Wow. And I remember, because when I heard your initially, when I had learned about you and your services on the Summerly podcast, weren't you also talking about, or something had been brought up about the attorney or the client shoes? Something about
Oh,
shoes? Yeah.
that's a funny one. Um,
Um,
yeah, that's a long time ago. We had a case in LaBelle, which is the county seat of Hendry County over near my hometown of Fort Myers, Florida. And we had lawyers from out of town. They were from all over the country. We had some Kansas City lawyers and
mhm.
some Miami lawyers, and the Miami lawyers were the plaintiff's lawyers, and they thought, especially this one guy, that he would like to really show these jurors, and not mock jurors, trial jurors, that he was a good old boy, one of them. Well, his big mistake was his cowboy boots were brand new, and everybody spotted a fake because they wear cowboy boots. There's a lot of people who have ranches and farms in Hendry County, but their
Mhm.
boots are not real expensive boots that have never been worn except for that day in the courtroom. So he was kind of exposed as a fake. I heard the jurors kind of laughing and talking. Can you believe this guy from Miami with those boots?
Yeah.
So
Oh
be
my
yourself.
gosh. Yeah.
Yeah.
I remember hearing that. I couldn't remember the exact story about the shoes, but I was like, and I remember, I think Robert Scarvone, who's actually been on my show too, at the time when he was doing this podcast, I think he had mentioned like, gosh, I can't believe that they would look at that. But it's true. It really, they have to like you. And it's not, uh, and it seems so, I guess, basic for a lot of people, but it really isn't. They have to like you. They have to like your client. I mean, it is, you are a package deal, at the end of the day.
And you just should be yourself. If you're the kind of person who is one way, then just be that way. Don't be
Hmm.
a different person, and don't have a fake car that you drive just to the courthouse because everybody just saw you at the grocery store in your red Porsche.
Right.
So that's another thing. Be yourself.
Yeah. Yeah. Definitely, that's super important. As you know, this show is called Chromatic Counsel, so I love to ask all of my guests a color question. And my question for you is, do you have certain colors or maybe even just outfits that you gravitate towards when you're getting ready to, work with an attorney on an upcoming trial?
This is a fun question, so I'm glad you asked it. I love green. I really love green. My lava lamp, which is off camera, has green wax. I have a green chair that I'm sitting in. I'm wearing an emerald ring, and I really love St. Patrick's Day. My husband's birthday is St. Patrick's Day, and the
Oh,
whole house
wow.
decorated in green. But that being said, notice I'm wearing blue. And the
Hmm.
reason is my husband's a photographer. He always said wear blue on camera because white's too harsh. And then when I go to the courthouse and help attorneys, I look like them. I wear a black, navy blue, or charcoal gray suit. And that's it. And
Hmm.
that's what they're wearing too, at least on jury selection day. I don't know after that, and I try to just blend in and be one of them. But on my personal time, I'm more bohemian. I like a lot of multicolor stuff, psychedelic colors, and I really like Lily Pulitzer stuff. I live in South Florida and I like that whole tropical vibe.
Yeah. Well, and two, here in Florida, we're both wearing blue, but just different shades. I'm wearing more of a powder blue, and you're more, it looks like a navy blue. And blue's our trust building color, which I love. And I have it in our logo too, kind of like a almost like a turquoise with the color and the logo. But yeah, here in Florida, that's the other thing too that influences a lot of things. And we've had certain court systems that like during like especially closer to where you are in South Florida, where during the summertime they relax the dress codes a little bit because of the heat. I don't think people realize if they come here for a trial, like especially between anytime between I think June all the way through the end of September, it's like walking into a preheated oven. It gets so hot here, and if you're not used to it, it can be pretty brutal. So
True.
yeah. So if you could give attorneys just one piece of advice to improve how they connect with jurors during trial, what would it be and why?
One piece of advice would be listen, really listen to what the jurors are telling you when you're selecting a jury. And when you have those 6 or 12 jurors selected, or if you're in another state, however many you have, pay attention to what they've told you in voir dire,
Mhm.
and then use their answers to weave them into your story of the case. If somebody says, "Oh, well, I like black dogs or something in voir dire. Well, this kind of reminds me of the black dog or whatever it is. But the attorneys, a lot of times I find they don't really listen. They're getting the answers and then quickly moving on to something else without really processing what that answer means. They're not
Mm,
actively listening.
yeah. Yeah. And and again, I think it's sometimes it could be the lack of experience with it, with doing trial work. It could be, like you said before, it could be a multitude of things, but I love that you shared that. And just in closing, I wanted to ask you as well, is there anything you'd like to share that you have coming up with the listening audience that you would just kind of like to say in closing?
Well, I do actually. Thank you for asking that question. I have written a book and it's somewhat related to what we've been talking about. The title of the book is The Social Psychology of Etiquette. Please don't kick the cat.
Oh,
And
wow.
the audience for the book, yes, could be lawyers. You wouldn't believe some of the things I've seen, but it's also anyone who really wants to learn why we have the rules of etiquette. Social psychology explains the reasons why. Why do we do certain things? We have a lot of situations now where decorum has gone out the window and people
Mhm.
are yearning for etiquette. um, Zoom conversations like this, they've replaced in-person meetings a lot. So what do we do? And I've got a lot of tips on how people can understand instead of, oh, do this because told you to,
Mhm.
just do this because here's why. And I give a lot of good examples. And it's time to bring back some decorum and niceness in our lives, and that's what the book is about. I'm hoping to get it published. It's finished, and the one overarching theme, of course, is just never kick the cat in whatever situation you're in, and it's a good theme and analogy throughout many situations.
I love that title, and I would have to agree. Having two cats of my own, I could totally agree with that. So I love that. And that's coming out, you do you know when or
Hopefully soon. We're actively looking for a publisher right now.
okay, okay. Well, we'll be on the lookout for that. And of course, if anybody would like to check out when that might be coming out and to learn a little bit more about Dr. Pigott and her services, there's a link below in the show notes that you can click on. And I just want to thank you so much, Dr. Pigott, for being on the show today and sharing some of this great knowledge with us. And I hope that we can have you back on sometime in the future.
Thank you. It's been a real pleasure, and it's been nice meeting you, and I hope to see you again.
Absolutely. And I want to thank everybody for tuning in today. That is a wrap for this episode of Chromatic Counsel. If you like what you heard, I hope you'll click on the like button, click subscribe so you know when we launch our next episode of Chromatic Counsel or any of our color videos. And I hope you can tune in next time. And as always, I am wishing you continued success.